and a fatal flaw in the verdict, because it was not a unanimous verdict, and they did not follow the law the way it was given to them. We talk about how at best, if you look at juror number 3 and what he says, at best that's a non-existent offense of attempted reckless manslaughter from the Stanley case, right? I don't believe he had intent to kill, but maybe what he did had the capacity to. That's reckless manslaughter, and there is no such thing. And I guess I'd ask you to consider this. I mean, I know this isn't exactly what happened, but it's pretty close. Let's say a jury, and and it's an important case. Obviously, he was facing life in prison, right? And let's say someone's facing life in prison, and a verdict comes back, and the juries find the defendant guilty of, let's say, murder. Let's say murder first, where he's going to be life without parole, the harshest sentence in our state. And then the foreperson walks out of this courtroom, and then there's cameras there, and the foreperson says, at her own volition and no prompting, well, you know what? Yeah, at the end of it, 6 of us thought he was guilty, 6 of us thought he was not guilty, that they didn't prove it, but we just returned a verdict of guilty. I have a hard time believing that our appellate courts would let that stand. I mean, I would have a hard time believing this court would let that stand. I mean, that would be absurd. And that's essentially what they're asking you to do. Maybe not to that extreme, but pretty close. Pretty close, when we know a juror has said they were not unanimous as to a required element, and she herself has said she didn't believe he was guilty of attempted murder. Meaning, at best, it was 11-1, which that's not what she was saying, but we can't just ignore this. We can't ignore this, and we have an opportunity to fix it. Just to address some of the prosecutor's arguments, we're not invading the power of the jury to act independently. I'm not sure what they mean by that, but we're not. That's the part, the independence of being able to think through things, consider evidence this way, give credibility, weight that way. Yeah, that's their independent right. What they don't have a right to do is not follow the law. That's different than invading their power to act independently. We're not invading jury secrecy. They came out and she said what she said. When you allowed us to talk to her, she said what she said. We never did, nor will we ask her. We didn't ask her. Why did you? How did you end up over there? We're not invading their secrecy. We're not invading their freedom to deliberate. We're not harassing any juror. All of these statements were made freely at their own will. So, I mean, that was the gist of a lot of their opposition, is these policy reasons behind this. We're not violating that. And then again, it's a balance. Yeah, we don't want to inconvenience any juror, make any juror feel uncomfortable, but we also want to get it right and make sure that there was not an illegal verdict under the Constitution. For these reasons alone, a new trial must be granted. The text messaging, and again, we objected to this being broadcast nationally, but it was allowed. And, then a commenter on one of these live streams commented during deliberations, before the verdict was returned, I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. And there's a couple of significant things about that. It says, I've been texting with, which infers a conversation, multiple texts. I've been texting with one of the jurors. It infers an ongoing conversation. The use of the term count 3, they're going for count 3 attempted manslaughter. No one in this courtroom ever referred to anything as a count. Nobody said the lessers is count 2, count 3. Nobody said that. We pointed out how in the statements to the media, one of the jurors did use the term, we went through all of the counts. So one of the jurors in the deliberation room, apparently the term counts was being used, even though we didn't use it in this courtroom. And now this person is using the same term, they're settling in on count 3. What else do we know about that? On the verdict form, although it was not indicated as counts, the third option, which would be, if you wanted to consider them counts, count 3, was extreme mental emotional distress, disturbance, manslaughter. So he said, And presumably, I don't even know I don't think the verdict form was even publicly accessible at that time. So some guy, wherever he was, and somewhere on the mainland, would have never known that count 3 was extreme mental emotional disturbance, or at least the third option in the verdict form. But he used that term. He didn't just say they're going for attempted manslaughter. He said they're going for count 3 attempted manslaughter, using the same reference to count as a juror did to the media, and picking the number on the verdict form that was EMED. And then lastly, that he correctly predicted the verdict. I mean, that, and there's case law we cited about the import of when somebody correctly predicts something, you know, how it provides an indicia of reliability. So there is indicia of reliability to lead to concern because of that. And I don't believe it is something where we can say, maybe it was just this or maybe it was just that. Remmer versus United States, the United States Supreme Court case. Private communications with jurors during trial concerning matters before the jury are presumptively prejudicial. Presumptively prejudicial. And the burden rests heavily upon the government to establish harmlessness. That's our United States Supreme Court. Our Supreme Court, 76 Hawaii 172 State versus Furutani. Once a defendant makes a prima facie showing that an improper influence may have affected the jury, prejudice is presumed. Prejudice is presumed. And the state must establish beyond a reasonable doubt that this misconduct did not affect the defendant's substantial rights. From what we've submitted and the arguments we've made and the inference and the indicia of reliability related to count 3, accurately predicting it, the timing of it all, we've made a prima facie showing. Burden shifts to the state to establish beyond a reasonable doubt that it did not happen or did not affect his substantial rights. What did the state do to meet this burden? Nothing. Nothing. It doesn't appear they went and, you know, you just saw they have investigators that work for them full time. Probably many of them. And that's why we put the burden on the government, because they're the ones with the resources. They're law enforcement officers with the right to subpoena things, to get search warrants, to interview witnesses. You know, if they believe there was tampering with a juror, that could be a crime. They could, you know, call people to the grand jury. There's any number of things they can do to meet this heavy burden of trying to show beyond a reasonable doubt that my client's rights were not affected. They did none of that. Call your investigator. Tell us what you did to figure this out, because I would assume you'd want to figure this out. I'd assume you'd want to know, in your role of seeking justice, not just convictions, did this happen? This is concerning. We should look into this. It's not only our burden, but it's our ethical duty to, if there was misconduct here, we want to know. What did they do? Nothing. I don't think they wanted to know. I think they were afraid of what they would have learned. So a prima facie showing has been made, and they have done nothing to meet their burden to establish beyond a reasonable doubt that this misconduct did not affect my client's rights. Prejudice is presumed. We don't need to show harm. Prejudice is presumed. State versus Furutani. Remmer versus United States. Presumptively prejudicial. I come back to what I said earlier, Your Honor. This motion raises important questions about what you are okay with in your courtroom. And I mean that respectfully. Do the jurors have to follow the instructions? The jury instructions, I'm not going to go through all of them, but you know, many of them directly call into question what happened here. You are the judge, this is number 2, page 2, from the instructions. You are the judges of the facts of this case. You will decide the facts, what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. They're told they have to follow the way the law works. Page 16 of the instructions. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required state of mind, as these instructions specify with respect to each element of the offense. That's the law. They took an oath to uphold that. We now know that that was not a unanimous finding as to the requisite state of mind. We talked about the elements on page 19 and what was required before they could unanimously find guilt on the attempted murder. We talked about how one juror said she didn't believe he was guilty of attempted murder. And then lastly, as to the text messaging issue, one of the last instructions that is given to them on page 43, during your recess from deliberations when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and has been received by the court. It's one of the last instructions you gave them, which raises the question, do jurors need to follow the law in your courtroom? Of course they do. Of course you're not okay with that. It would be an incredible coincidence if somebody, prior to the verdict, used the term count when nobody in this trial used it, and then the jurors used it, that they would know it was the third option on the verdict form, and that they would know and accurately predict the verdict. It would be an incredible coincidence. And we can't, there's too much at stake to just assume that it was some lucky guess. We have established a prima facie showing. There's presumptive prejudice. They could have done any number of things to try and meet the burden to show that it didn't happen. In closing, Your Honor, I'll say this.